Thanks so much, Pam, and glad to be back. So today we're going to continue some of our lectures from cutting edge research in humanities, and we're really happy to have Joseph Angelillo with us. Joseph received his PhD in history from the University of Florida just in July, last month. Congratulations. A historian of the Civil War era, he's an incoming constructor of legal history at the University of Alabama in Tuscaloosa. His work concerns the institution of the jury during the Reconstruction era. His presentation today is entitled Putting the Genie Back in the Bottle, Alexander Reeves, Southern Juries, and the Lost Potentials of Inclusion. Go ahead. Thank you.
I appreciate that, Rick. I appreciate the introduction, Rick. Last time I was here, I kind of danced around the wooden floor and I was all over the place. I'm afraid I'm going to stick a little closer to the podium this time. So for those that were here last time, I'm sorry. It's not going to be as much movement. I will do my best to hold your attention otherwise. As Rick said, my name is Joe Angelillo. I did just finish my PhD at UF about 20 days ago, which is cool. And I would also like to commend Rick. You pronounced Reeves correctly, because when I first saw this guy's name, I thought it was Rives. Why? Because I guess that's how it looks. Well, it turns out it's Reeves, like Christopher Reeves. So there you go. As you might see from the title, I'm here to talk about juries. My research is on movements for mixed race juries and all black juries during the Reconstruction era. And that's all well and good. I like my work. Maybe you will too. However, before I talk about juries, I would like to talk about the title of this talk. The title of this talk, as is, it's big old letters, is Putting the Genie Back in the Bottle. And this alludes, of course, to, this is a very common idiom, putting the genie back in the bottle. To put the genie back in the bottle means to reverse a situation, undo something before it takes hold. Undo something before it takes hold and usually causes some kind of permanent change, or at least something consequential. Typically, the genie is something very broad, something very consequential, something with the potential to cause a lot of change, or perhaps do damage. Maybe a lot of damage, maybe a little damage. At the very least, make something different than it was before. The common idea is that you can't put the genie back in the bottle. Once it's out, it's out. Didn't work for Aladdin, at least the legends of Aladdin. Obviously, there's the movie, but anyway, it didn't work for anybody else. Once the genie's out, the genie's out. But I would like to show you someone who did try and put the genie back in its bottle. This is Alexander Reeves. I would like to just upfront address the issue in the room. Alexander Reeves is a strange-looking individual. So we are going to move to a better image of Alexander Reeves. There we go. Okay, now that's better. Alexander Reeves was a federal judge in Virginia. There's a lot, and I do mean a lot, to unpack with Alex Reeves. People called him Alex Reeves, and he signed his letters Alex Reeves. I'll give you the main thing that's germane to this topic, though. Reeves, in November of 1878, let a genie out of its bottle. This proverbial genie was a very broad egalitarian argument, one in which Reeves held that black criminal defendants hold a right to judgment by black jurors. Let me say that again. Reeves held that black criminal defendants hold a right to judgment by black jurors. Reeves had sustained the appeal of two black criminal defendants who argued that they needed black jurors on their jury so to have an impartial trial. So we're getting at words and phrases that are associated with jury service, like impartial. In sustaining this appeal and granting this appeal, Reeves argued that black defendants were entitled to judgment by at least some black jurors. This argument was a genie. This argument had the potential to completely uproot the system of the jury as we knew it. It had the potential to establish new principles. It had the potential to upend criminal procedure. And most importantly, it had the potential to set new definitions for core terms in a democracy, like what it means to be a peer, what it means to be impartial. By March the next year, March 1879, Reeves had put this genie back in the bottle. He dropped his argument. He was pressured to drop his argument by this fella here, Charles Devens, who looks like he was on the Titanic. I don't know why. That's the first thought I had. He wasn't. Anyway, Reeves put the genie back in the bottle at Devens's pressure. This talk is about these events. Well, how Reeves let a genie out of its bottle, why Devens pressured him to put it back in, and how all of this led to some very crucial Supreme Court case law regarding juries and race. We start in Patrick County, Virginia in 1877, which is there. Patrick is a small county at the Virginia-North Carolina border, so that's Virginia. North Carolina's there. It only housed about 12,000 people at the time. This was kind of a smallish, somewhat sleepy county. There are much more rockin' places in Virginia. But in this small county, probably a sleepy county, a murder took place in November of 1877. The victim was A.J. Shelton, a local white man. A.J. Shelton, apparently, the reason he was murdered, apparently a couple of individuals who were two black men named Lee and Burwell Reynolds. Apparently, these individuals had verbally harassed Shelton's younger brother, so Shelton tried to confront them, and then a fight broke out, essentially, is the story. This was the Reynolds case. The individuals indicted for the murder were the individuals that Shelton had confronted, Lee and Burwell Reynolds. Lee and Burwell Reynolds were black men, though it is rather odd to describe them as men when they were aged 18 and 17, respectively. These were young individuals. They were taken into custody and charged for the murder. Both of them were facing charges of first-degree murder. One of them was facing life in prison. The other was facing the death penalty. How does this have to do with juries? Well, the jury-related drama starts almost immediately when the lawyers representing the Reynolds brothers notice something. These lawyers were two Confederate veterans. One of them is pictured here, William T. Martin, and the other was a guy named Andrew Murray Liebrook. Why do I have a picture of William T. Martin? Because of all the people involved in this case, from the Reynolds brothers to Shelton to the other attorney, this is the only one who has a picture publicly available. I could not find a picture of the Reynolds brothers or any of the other individuals. Now, Liebrook and Martin noticed something about the jury veneer. Before we continue, what is a veneer? A jury veneer is a pool of possible jurors. So basically, has anyone here been called for jury service? Not necessarily served on a jury. Has anyone at least been called for jury service? Okay, so most everyone here has been at least called for jury service. That means you were in the veneer. You were in the pool of possible jurors. If you don't mind me asking the people here about how many other people were called when you were called for jury service, about how many people were in the room when you were called for jury service, ma'am? About 30? About 30? 25? 40? Okay. So this is, the sizes of veneers vary. Sometimes they can be massive. Sometimes they can be in the hundreds. Other times they can be more like essentially just the jury times two, right? And you strike about half of them. Either way, the veneer is about this is at the time the veneer that was drawn for the Reynolds brothers case, something about 25-ish. That was pretty typical in U.S. criminal justice procedure. Most people are called on to veneers at some point in their life. And it is not nearly as common, of course, to actually serve on a jury. The final jury is known as a petty jury. It's not spelled petty like P-E-T-T-Y. It's spelled P-I-P-E-T-I-T. It's Latin. They've got crazy stuff. Anyway, Liebrook and Martin looked at the veneer from the Reynolds brothers, And notice something. It was only white people. Now, Liebrook and Martin found this rather distressing. Why did they find this distressing? As would be revealed in their legal petitions, they believed that their clients, who were both black men, could not achieve impartial justice, whatever that is definition of their whatever the definition of that is, that they could not achieve impartial justice in the courts with only white jurors. As is quoted from one of their petitions, they cannot obtain an impartial trial before a jury composed exclusively of the white race. That was their words. Notably, however, it was not the law of Okay, can people hear me now? Okay. Honestly, I'm just going to hold it in my hand. I'm kind of leaning right here by doing this, and I think it looks a little weird, so I'm going to stand upright with it in my hand. Okay, wonderful. We are moving along. It was not the law of Virginia that had excluded black jurors from the Reynolds brothers jury veneer. The law of Virginia was, as we would call it today, colorblind. It held that pretty much any white man, or pretty much any man in Virginia aged 21 up was eligible for jury service. The law of Virginia did not mention the word race. While this law was colorblind, Liebrook and Martin argued that it still required black defendants be judged by black jurors. So, Liebrook and Martin filed a petition to reconstruct the veneer. They asked that 1/3 of the veneer be composed of black jurors. They did so because they believed that this would deliver impartial justice. That was the idea, that black jurors would deliver impartial justice. As you can see here, it says attorneys petition for removal. We're going to get back to that in a moment. First thing we have to mention here is that whether or not Liebrook and Martin knew it, maybe they did, maybe they didn't, they were tapping into transformational intellectual currents espoused throughout Reconstruction. The core message of these intellectual currents was that purposeful inclusion of black jurors created impartial jury trials for a black defendant. Purposeful inclusion of black jurors ensured impartial justice for a black defendant. That was the core message of these transformational ideals. This rhetoric, these transformational ideals, largely relied on a racialized definition of peer, as in jury of your peers. Black activists typically defined peer in a racialized sense for two reasons. Number one, they argued that black jurors would add contextual knowledge to jury deliberations. The argument here essentially was that black jurors understand the lived experiences of a black person because they also are dealing with the issues of race. Because they understand these lived experiences, they would help ensure that the deliberations for a black defendant understood the defendant's context, understood where they were coming from. Not necessarily to excuse actions, but at the very least to explain actions. So that's the first reason that people defined peer in a racial sense, because of the idea that black jurors understood the lived experiences of black defendants. The second reason was that white jurors did not understand lived experiences of black jurors. Many activists argued that white jurors were too prejudiced to stand as peer for a black defendant. Obviously, in the context, this is within 2 decades of the end of the Civil War. This argument does have some legs. The argument went that a peer is supposed to understand the defendant. Whites, infected with a very deep racial prejudice, probably did not. So that was those are the arguments that surround the racialized definition of peer. There was also rhetoric that essentially argued that black people would offset or counterbalance or undermine the prejudice of white jurors. This explanation was largely deployed by white Republicans who were very worried about the legitimacy of Southern law enforcement. Excuse me. One of these white Republicans was quoted as saying, "Bitter as is the prejudice against you, you require something to balance and offset that prejudice." Another said, Black citizens must offset race-hating and vindictive white ones at elections, on juries, and wherever else the duties of citizenship are to be exercised. Now, why do I read you these quotes? I read you these quotes because these quotes don't mention the word peer. They don't mention the word impartial. But they do show us that there are different ways to support this notion of purposeful inclusion of Black jurors that don't rely on this question of peer, of a question of impartial. We do see a concern here for white prejudice, though. Very rarely, demands for purposeful inclusion of Black jurors actually did not care about the defendant as much. Very rarely, these demands concerned the rights of the juror themselves, not the defendant, but the juror. Such demands were mostly concerned with demonstrating that Blacks and whites were equal. The idea being that if Black people were serving on juries and they were doing so well and impartially, it would show to white people that racial inequality was a myth, because of course it's a myth. Essentially, this was an argument saying that Black people have a right to sit on juries, so to undermine prejudice. That was far and away the less common argument. Much more common was rights of the defendant, not rights of the juror, rights of the defendant. These ideas had some influence on Republican lawmakers. In 1875, they had passed a law outlawing race-based jury discrimination. In debating this 1875 law, many Republicans argued that they were protecting not the rights of the juror, but the rights of the defendant. They also argued that the law should create a positive duty to seat Black jurors. One senator argued that there must be an affirmative duty to ensure the construction of a proper jury. An affirmative duty to ensure that the jury is constructed properly. Essentially arguing that there has to be some purposeful inclusion of Black jurors in order to ensure justice for a defendant. So, we can see a lot of intellectual shifting regarding the jury in Reconstruction, but a few themes emerge. Many demanded purposeful inclusion of Black jurors, so to create impartial trials. They argued that the meaning of peer had been racialized, and they centered the rights of Black defendants. This petition, put together by Martin and Liebrook, this petition tapped into these roots, whether or not they knew it. But their petition was denied. They did not receive a mixed jury in that moment. So they filed a different petition. This petition was for removal. So what's removal? What is removal into federal courts? Removal into federal courts is a very strange procedure that almost never happens. As a matter of fact, I can't find an instance where it actually has happened. It is still legal, and it's in the U.S. code that it can happen. I haven't found it ever happen, though, so that's something. Removal, if it happens, is supposed to be where you take a case from a state court, put it in a federal court, and it starts all over. You have a new judge, you have a new jury, you have new attorneys. They basically argue the case anew. The idea of removal is that sometimes in a state court, you might find the procedure is going badly. You might find that the judge is prejudiced, or the jurors are prejudiced, or the attorneys are prejudiced. Point being, the idea is that if you're in a state court and there is a problem, that defendant is being denied their rights in some way, you can just take the case out of the state court and put it in the federal court. Essentially, it's just doing the case over in a separate venue. The petition for removal said essentially that the Reynolds brothers had a right to a mixed race jury. That right was denied, so they needed to try the case in a different venue. The petition was made to a certain judge, a judge by the name of Alexander Reeves. I know what you're thinking. Why did I not use the better picture of Reeves? Okay, that's my fault. You have to look at this picture of Kermit the Frog. Anyway, Alexander Reeves was, at first glance, an odd choice for an ally for criminal defendants. Reeves was born to a very wealthy and influential family in Antebellum, Virginia. Has anyone here ever heard of the First Families of Virginia? That's a thing, apparently. And they, by the way, they call themselves that. People do not say these are amazing families. They are the first families. They all got together one day and they were like, hey, were the first families of Virginia. So that's not pretentious. Anyway, Reeves was born to a first family of Virginia. He practiced law in Virginia. He got a legal education at the University of Virginia. He practiced law in Charlottesville. He stayed in Charlottesville. Through all of it, this man was not particularly good to black people. For one, he was once a Jacksonian Democrat, and the Jacksonian Democrats are probably one of the more pro-slavery political parties in U.S. history. More importantly, Reeves was an enslaver. He himself owned 66 slaves. His family, the Reeves family, altogether owned about 200 people. Actually, fascinatingly, speaking of Alex Reeves and his slaveholding, when I was doing research on this individual at the University of Virginia, one of the librarians there, a wonderful woman by the name of Regina Rush is descended from the family that Reeves enslaved. One of the librarians walked up to me and said, "Oh, you're doing research on Alex Reeves. That's cool. My great-great-grandmother was enslaved by his brother." What a moment that is. Can you guys believe that? I couldn't believe it. And it really adds a layer to this research, when you do research in history, when you research the past, so commonly these are just names and sometimes pictures that look a little odd. So commonly these are just names on a page and ideas and abstract ideas, and it seems like you're writing a story, and it's so hard to grasp the fact that these things really happened. And so for this librarian, Regina Rush, to come up to me and tell me that this involved her family, it was, oh my gosh. I mean, it tells you that there is reality in these stories that we tell. And Reeves was an enslaver. But despite his enslaving, Reeves was known as a passionate, lifelong Unionist. In the 1830s, South Carolina had tried to nullify federal law. Reeves hated that. In 1861, his home state of Virginia was on the verge of seceding from the Union, and of course they did secede. Reeves was at the secession convention arguing against secession. He was trying to sway the delegates away from leaving the Union. Once Virginia had seceded, Reeves resented the Confederacy. In fact, he was writing to a friend, and he said the following: "I don't know our new president," the new president being Jefferson Davis, president of the Confederacy. "I don't know our new president or any member of his cabinet, nor do I owe them any goodwill for their overthrow of our late Union. This man loved the Union." This unionism led Reeves into Republican ranks after the war. He eventually emerged as one of the most prominent Republicans in Virginia. And in 1870, he ran for Congress. He lost. Republicans didn't do terribly well in Virginia in the 1870s. So he lost his seat for Congress, and President Grant does what the president tends to do when someone goes to bat for their party and loses. He gave him a little bit of a reward. What was that reward? The reward was a seat on the federal judiciary. As a reward for this service, Grant appointed Reeves federal judge for the Western District of Virginia. Reeves took this seat in February of 1871. As a federal judge, Reeves had a lot of juror issues and jury experience. Of course, as a judge, obviously, you're going to deal with jurors a lot. But Reeves' experiences are important. For the one, Reeves presided over the prosecutions of the Ku Klux Klan in Virginia. These prosecutions happened across the South, and so they happen in Virginia as well. In these cases, Reeves watched as all white juries acquitted clearly guilty white terrorists. And by the way, let's make sure we're straight here. The Ku Klux Klan was and is a terrorist organization. Reeves watched as all white juries looked at Klansmen, discussed among themselves how he had probably done it, and then found him not guilty. Reeves watched that happen. So Reeves had suspicions about the fairness of all white juries. For another, Reeves had presided over mixed-race juries. There was actually a newspaper interview. That fell on the ground. It's fine. In a newspaper interview, Reeves had said, "I have always ordered mixed juries and have not discovered that harm has resulted from it. On the contrary, the lawyers seem to prefer them." So Reeves, altogether, he resents secession. He saw all white juries nullify the law, and he used mixed juries. These all speak to a common idea. Reeves saw all white juries whether for a black defendant or a white defendant, as undermining the reconstructed constitutional order. So, with these experiences in mind, in 1878, the Reynolds brothers petition for removal into his court. Reeves grants that petition. He grants that petition in a case known as Ex parte Reynolds. It's November 1878. In this opinion, Reeves held that black defendants have a right to judgment by black jurors. Reeves hinged this argument on two ideas, or as we can see here, two arguments. So the overall holding, black defendants have a right to judgment by black jurors. The two arguments that help Reeves get to that. Argument one, as Reeves wrote, and as you can see, equal protection can only be had in criminal trials through juries composed of the same persons. We've kind of talked about this notion already. This is the idea that fair justice means judgment by people who understand the defendant, or at least who occupy the same status as the defendant. This idea echoed the intellectual notions espoused throughout Reconstruction, the idea that impartiality requires inclusion. So that's argument number one. Argument number two, absence of black jurors evidences discrimination of black jurors. Reeves essentially argued that all white juries don't just happen. Reeves argued essentially that if there is an all-white jury, there had to have been discrimination because these things don't just happen. It was proof positive that there had been race-based jury discrimination. And this is something of a new argument. This wasn't an argument that had been relied on throughout Reconstruction. So with these two arguments, argument one, argument two, and if you can, keep these in mind. Argument one, equal protection means judgment by peers, essentially. Argument two, no black jurors means there's discrimination. Keep those in mind if you can. With these two arguments, Reeves argued that the Reynolds brothers held a right to judgment by black jurors. Virginia courts had denied this right. So Reeves sustained the petition for removal into his court. All of this is well and good for the Reynolds brothers, and it was well and good for Reeves. Reeves's opinion was probably the broadest argument for black jury rights espoused throughout Reconstruction. Ex parte Reynolds is a rather remarkable primary source. It's pretty incredible to read. He's not the best writer, but once you sort through all the commas, you kind of, or rather, it's not that there's too many commas, it's that there's a lack of commas. This dude was writing run-on sentences like his life depended on it. Anyway, once you sort through all that, what you find from Ex parte Reynolds is that it's a rather remarkable opinion. But there was one person who wasn't so happy with this opinion. That person was Charles Devens, the Attorney General. This is an image of Charles Devens, obviously during the Civil War. He was a Union general. Fun fact about Charles Devens. Charles Devens, as you can see, frequently wounded. Frequently wounded is an understatement. Devens was shot in 3 different Civil War battles. The dude could not stop being shot. And then, do you know what happened when he wasn't shot and Antietam? His horse was shot out from under him. So in 3 separate battles, he took a bullet. In the 4th one, he's riding his horse, and then suddenly there's no horse. So the guy was an absolute bullet magnet. I don't know why he kept coming back into the battlefield. Okay, maybe he's brave or something. I don't know. Huh? He had to collect them. I would hope that he would collect them, right? I mean, that'd be kind of, that'll just be a little messed up, but maybe he's coming to terms with this trauma. I don't know. Anyway. So Charles Devens, beside being a collector of bullets, in a way, Devens was Attorney General. He was the most senior legal officer in the United States. He was in charge of the Department of Justice. He had been Attorney General throughout the presidency of Rutherford B. Hayes. Devens had taken over the DOJ at a time of cutting cost. The DOJ budget peaked in 1873 at just over $3 million a year. In 1878, this had fallen to $2.6 million, which is a 13% reduction in that 5-year period. Why was the DOJ so concerned about cutting costs? It's hard to say. There had been an economic panic in 1873. In 1873, they called it the Great Depression back then. That was at the time the Great Depression. And then there was another one in 1893, and then that one was the Great Depression. And then, the actual Great Depression happened. And then in 2008, okay, I don't need to bore you with economic history. Point is, in 1873, there had been a big economic setback that at the time was the worst ever. So this might have been motivating Devins to cut costs. The panic of 1873 was still reverberating 5 years after it happened. Also, Devins was a Republican, and the thing is, the Republicans had the most sticky political charge against the Republicans was that they were corrupt. And so maybe this is Republicans trying to fight charges of corruption. I can't tell you why Charles Devins and the Department of Justice were so I can't tell you why exactly they were concerned about cutting costs, but the fact is they were very concerned about cutting costs, especially the cost of federal prosecution. Federal prosecution is not cheap. Federal prosecution costs a lot of money. The main reason here was that in the 1870s, the only people you didn't have to give extra money to in a prosecution were the attorneys and the judges. They worked for salary. Everyone else, you had to set aside money for a new case for them. This means you have to pay federal marshals to keep people safe. You have to pay jurors. Jurors you have to pay. You have to pay them $3 a day back in 1878. You have to pay witnesses because witnesses are giving up their time, so you do have to pay them something. And you have to pay commissioners. You have to pay people who select the jurors. Indeed, a lot of pieces of a court case are paid on a per diem basis. This means new case is new costs. The Reynolds case provides a very fitting example of how this works. Because, Reeves had ordered removal. Reeves had ordered removal of the Reynolds case from state courts into his courts. That's cool on paper, but then things actually have to happen. For one thing, you have state prisoners that now have to become federal prisoners. So you have to go send federal marshals to go get the Reynolds brothers and bring them into a federal prison. Then you have to go hire a jury commissioner to summon 25-ish jurors. That jury commissioner is going to have to be paid for a few days of work. Obviously, you have to pay marshals to protect the prisoners over the next few days because Virginia whites were very angry about all of this. There were certainly fears that there would be extra legal killing. And of course, you have to pay the jurors for their work, which will probably be about a week's worth of work, and you have to pay the witnesses. All of this means that the Reynolds case was going to cost more money to the federal government. But hey, it's just one case, right? It's just the Reynolds case. Yes, there's two brothers and you have to try them separately. So it's just two cases, right? It's just two cases. Here's the problem. It wasn't just two cases. It was a lot of cases because Reeves had argued that black defendants hold a right to judgment by black jurors. He said that this was a right. It was something that defendants are guaranteed to. If this right stood vindicated, then any time a black defendant faced an all-white jury, they could petition for removal. This meant that every time a black defendant faced an all-white jury, they could initiate the very same costly procedure multiple times. How expensive was this going to get? The answer is very expensive. We know it was expensive because this did not occur in a vacuum. Black citizens were well aware of the Reeves drama. They were well aware of the Reynolds case. Black citizens took note of the ex parte Reynolds opinion, and they launched a movement to support Reeves, and they launched a movement to support the right of black defendants to judgment by black jurors. What do I mean by movement? I mean that black citizens, especially in Richmond, Virginia, started fundraising for Reeves. because they understood the case was probably going to go to the Supreme Court. Black citizens started writing to Attorney General Devens, asking him to make sure that the Reynolds brothers were tried in federal court and not in state court. And these actions are important. But the most important events came in May 1879. In May 1879, a group of black activists, they were led by a fellow named William C. Roane. Once again, I cannot find a picture of William C. Roane. Turns out the 19th century, fun fact, the most photographed individual in the 19th century was Frederick Douglass. Something of an exception to the rule here, because typically the most photographed people were white people. So I cannot find a picture, sadly, of William C. Roane. William C. Roane led a meeting of black activists here. This is the Odd Fellows Hall on Franklin Street in Richmond. This is the meeting place for the International Order of Odd Fellows, which was it's a national fraternal organization that after the Civil War actually had something of a sizable black membership. So Richmond's black elites very often met here. At this multi-day meeting, once again led by Roane, William C. Roane gave a speech. Here's what he said. He thought it useless for the colored people to look further to the president and Congress. The president and Congress had done all about they could. They must now help themselves. They had been deprived of their right to sit on juries simply because they had never protested against it. In other words, what Roane said here, it was time for black people to start demanding purposeful inclusion, not to Congress or the executive branch. They had tried that. It was time to go to the local judges. It was time to lay out a plan for going straight to the judges themselves. The plan was that black leaders would return to their communities and they would form executive committees, what they called them, executive committees. These executive committees would be formed for the express purpose of petitioning local judges to seat black jurors. If the judge refused, this refusal was going to be written down and then presented to the legislature. This plan of going to the judges and demanding purposeful inclusion and then recording refusals, this plan had some precedent. There had been similar movements in Richmond a few years earlier, and also one in Knoxville, Tennessee. These movements had been about going straight to the judges and demanding purposeful inclusion of black jurors. These movements had varied success, but they demonstrated that they kind of gave essentially a roadmap as to how to do this. So this 1879 grassroots movement had some precedent moving for it. This jury movement wasted no time in setting their plan into action. By late May, Roane was marching with 7 others, and when I say marching, I mean the newspapers described Roane and 7 other black men marching in single file down Main Street. Imagine that scene. Roane marched into City Hall, into the private office of this fella here. This is George Llewellyn Christian. He was the local judge. He had fought for the Confederacy. Roane marched into this local judge's office and presented a petition that Christian needed to start seating black jurors if he was dealing with a black defendant. In June, Judge John Wesley Bell, he was in Culpeper County, Virginia, he received a similar petition. And then also in June, Judge John L. Cochran of, I'm going to pronounce this right, I hope, Albemarle County, that's Charlottesville, essentially a local judge in Charlottesville, received another petition. All of these petitions were demanding black jurors for black defendants. The movement even spread outside of Virginia. In Memphis, Tennessee, which is my hometown, and in Louisville, Kentucky, the same story occurred. Local judges were getting petitions from these black executive committees demanding inclusion of black jurors. So we have a movement here inspired by Reeves going straight to the judges. These are commendable efforts, I think. These were black citizens demanding judgment by their peers, demanding that the courts do something to bring them safety. But for Charles Devens, this was not a good thing. This was a problem. Because Devens looked at this movement and saw the potential for dozens of new removal cases. The black movement was demanding that judges seat black jurors, and they are recording refusals. That means that this movement is writing down a lot of evidence. This evidence could be used to initiate more cases of removal. Reeves had argued that black defendants were entitled to black jurors. And basically, this black movement showed that the extra costs of federal prosecution would not stop with the Reynolds case. Black citizens would demand inclusion, and they could use Reeves's principles to achieve it. So Reeves and Devins needed a way out. They needed a way to put the genie back in the bottle. The genie was out. The genie was the broad argument that black defendants are entitled to black jurors. The genie was out. They needed to put it back in because to them it was too costly. So they started to look for a way to put the genie back. But Reeves did not have to look far. Remember, he had espoused two arguments. One, black jurors hold a right to judgment by black defendants. Black defendants hold a right to judgment by black jurors. Two, argument two, absence of black jurors prove that a judge was discriminating. The first argument was the expensive one. That's the one that could lead to tons of removal cases. The second argument was not nearly as expensive. It required a prosecution, but a prosecution of judges, and a prosecution that probably, Reeves would hope, would deter further law breaking. So Reeves pursued an alternate course. The alternate course was by privileging his second argument, and under this second argument that absence of jurors means that there was discrimination, the alternate course led Reeves to indict 5 Virginia judges for excluding black jurors. He explained his actions in a letter to Devins in which he said, "I am appalled at the cost of the removal cases, the Reynolds to the U.S. Hence, I esteemed it my duty to strike at the root of the evil and found indictments against all county judges save 2. So Reeves had found a way to put the genie back in the bottle. This quote proves that Reeves turned to indicting the Virginia judges not as a supplement, but as a substitute for his removal case of the Reynolds brothers, because he was appalled at the costs that he had incurred. So he decided to take a different route. And Reeves probably thought this was going to work. Reeves probably thought that by prosecuting 5 judges, the rest of the judges were going to get in line. Something like a shot across the bow to the other judges, right? If you prosecute one person for law breaking, everyone else will understand the consequences. That was probably Reeves's thinking. That instead of his costly removal argument, he could prosecute a few judges and everything was going to be okay. This satisfied Reeves, who still wanted to make sure that judges were seating black jurors. And it satisfied Devins, who had to make sure that costs were kept low. I want to make something abundantly clear here. This was Reeves and Devins prioritizing literal monetary costs. They privileged the issue of money. By doing this, they minimized what I would argue, and you might agree, you might disagree, you're entitled to your opinion. They deprioritized what I would argue is the more important issue, the rights of black defendants to fair judgment. Of course, we can disagree as to what fair judgment means. Fair judgment is a very amorphous idea. Impartiality is an amorphous idea. It's a nebulous idea. But Reeves had initially walked into this trying to protect the rights of black defendants. He pivoted because he became concerned with the rights of the federal government to save money, essentially. All of this impacted the case's Supreme Court review because, yes, this case did get to the court. The background is the Supreme Court under Morrison Waite. That's Morrison Waite there. He's the Chief Justice. He's one of the most inconsequential human beings ever born. I hate to say it. Sorry, Morrison Waite. The most important people on the court were him. We don't have to get into it. Okay. This case did get to the Supreme Court. When it got to the court, Devins argued that black defendants were not entitled to black jurors. So even before the case got to the court, as we can see, Devins and Reeves had undermined argument one. Instead, basically, Devins argued that black jurors hold a right to a jury that is assembled colorblind. In other words, a jury that is assembled without race being any part of the calculus. He also argued, of course, in favor of argument two, that if there were no black jurors, that was proof that there had been discrimination. The Supreme Court agreed with these arguments. The decision was known as Virginia v. Reeves. Virginia v. Reeves held that black defendants did not hold a right to judgment by black jurors. Black defendants instead held a right to a jury assembled without discrimination. There was also a second case. That case is Ex parte Virginia. Ex parte Virginia held that if the judges were excluding black jurors, then they were breaking the law. So argument one had been essentially done away with. Argument two had been sustained. The genie had been contained. So what happened to the Reynolds brothers then? I wrote this talk without actually putting that in here. I'll tell you what happened to the Reynolds brothers. The Reynolds brothers had been denied their petition for removal. They petitioned for removal because they said they were denied a right. The right was to a mixed jury. The Supreme Court said that right does not exist. So they did not get their removal into federal courts. However, their case was actually moved from one state court to a different state court. They were moved out of the area. Their case was moved from Patrick County to Danville. So they did get a change of location. They also got a mixed jury, which is a rather weird quirk of this case. They had originally petitioned for a mixed jury. They were denied a mixed jury. And then I don't know why Virginia judges decided to comply this time, but they did. Virginia judges essentially said, okay, game over. Let's give them a mixed jury. Originally, Liebrook and Martin had petitioned for a jury veneer 1/3 black. The final jury that tried the Reynolds brothers was actually 1/3 black. It was 8 whites, 4 blacks. Rather, like I said, it's an interesting tidbit to this case. And like I said, the Reynolds brothers initially faced charges of first-degree murder, punishable, one with death, one with life. They were found guilty of manslaughter and sentenced to 5 years in prison. So it's interesting because, in a way, their lawyers were right to a certain degree. That inclusion of black jurors had delivered a better result for their clients. Of course, this is an interesting argument because we don't know what happened in the deliberation room, and we can never know what happened in the deliberation room because jury deliberations are a necessary secret. But what happened to the Reynolds brothers? They went to jail for a few years. They avoided the hangman. And they got their mixed jury somehow. So they're something of an interesting, amiable outcome here. Judge Reeves retired in 1881. He died in 1886. Why does any of this matter? Why does any of this matter? It matters because during the Jim Crow era, Southern juries were almost universally all white. That could have been avoided. The Reynolds brothers got their mixed jury in a different way than they had intended. Black defendants across the South did not get their mixed jury during the Jim Crow era. This could have been avoided if the Supreme Court had sustained a right for black defendants to be judged by black jurors. Once again, we can debate what it means to have fair and impartial justice. But certainly the universality of all white juries in Jim Crow shows us that there was discrimination, and that discrimination could have been avoided. The argument was on the table. Reeves had espoused the argument, but he put that genie back in its bottle. This story also matters because it could have vindicated the intellectual shifts of Reconstruction. It could have vindicated the idea that the lived experiences of people matter. And if you want to judge somebody else, you have to understand where they're coming from. I think that's something we can all probably agree with, that you need to understand where a person is coming from if you're going to judge them. That idea could have been vindicated in this case. It would have been vindicated in a legalistic way, right? Obviously, in a very technical sense. But the underlying argument there had a chance. These principles could have ensured more impartial justice. But Reeves and Devins had lost their concern for the rights of defendants. What mattered was cost. The Virginia judge's case, Ex parte Virginia, I mentioned it earlier, the case about whether or not all white juries prove discrimination had occurred. Ex parte Virginia actually wound up getting a historical plaque rather recently, and I tend to disagree with this case getting a plaque because this case, even though it had broad potentials, this case had much broader potentials, if you will. Like I say in the title, like the title says, the lost potentials for inclusion. These potentials were lost because Reeves and Devins had lost their concern for the rights of black defendants. What mattered to them was cost. And so they forced Reeves's genie back in the bottle. Thank you. I will now move to what I did last week, which is being in the middle here so that there's a little more movement going on. Yes. Yes, sir. So that's a great question. Because obviously juries don't just see criminal cases, they see civil cases. That distinction was not really brought up in any of like the documentation behind this case. At the same time, the potential obviously was there, right? If the idea is vindicated that black defendants have to be judged by black jurors, surely that would have applied to both petitioners and respondents in civil cases, or at least that the potential is there. What I can tell you is that civil cases during the Jim Crow era were also tended to have all white juries. So the potential could have been there for that trend to be reversed. So the answer is, maybe. So in essentially in what could have happened, if you will, if that makes sense.
Other comments in the Oak Room?
Please, sir. All right, microphone.
You said Reeves substituted the rules to reduce removal as a you call it a substitute, but I saw that as offered as a cure for the disease rather than a different treatment. He was trying to, by doing that, there'd be no need for removal.
Exactly. And I think that I think you and I are using similar terms for the same thing here. Essentially the idea is that there is a issue that needs to be solved. The issue is that removal is rather expensive and needs to be limited. And so I call it a substitute approach because originally Reeves had one approach and then he took a different approach. And so what I say is he substituted one approach for the other. But the idea of this being a cure for a disease also makes sense, right? The disease is cost. Sure. And I think that's I think that's fair. I think that's fair. You know, the disease essentially being cost and the cost of removal, the cure being a way to move forward without that. Yeah, I like that. Instead of creating the symptom, you treat the disease. That's a good way to put it. I like that.
Other comments or questions? I have a general comment.
Sure.
Could you put these cases and issues in the context of the interpretation of the 14th Amendment with equal protection descending down to the states, and particularly the removal of federal troops in the South?
Okay, so that's a very broad question, but I'm happy to address it. In terms of equal protection, these two cases, you know, Virginia v. Reeves, Ex parte Virginia, those are the two cases that deal with the Reynolds drama, or at least the Judge Reeves drama, if you will. There was a third case that dealt with juries that came down on the same day. These were a trio of cases. They're known as the Virginia cases, or I'm sorry, the jury cases. The third one came out of West Virginia. Essentially, the way that these cases, these were the first cases to really provide an interpretation of the 14th Amendment's Equal Protection Clause. Previous 14th Amendment interpretations have largely dealt with the Privileges or Immunities Clause, which is a whole other bag of worms if you've ever heard of the slaughterhouse cases. Anyway, so this was the first time that the Equal Protection Clause had ever really been interpreted. And broadly, the court did arrive at something of an okay holding, which is that race cannot be used to keep someone off of a jury. I think most everyone can agree that's a good outcome, that race cannot be used to keep somebody off of a jury. Of course, what I argue is that there was potential for a much broader holding, but either way, this was the first time the court had essentially said that equal protection means that you can't keep, we're still good, that you can't use race as a discriminating factor. In terms of putting this in context of the end of Reconstruction and the removal of federal troops. So the end of Reconstruction is a very complicated thing. The story goes that in 1877, in order to take the White House, Rutherford B. Hayes bargained off the rights of Southern blacks and removed troops from the South so that he could take the White House. That story is pretty flawed for a lot of reasons. Probably the most important reason is that this was a policy Hayes adopted for about 2 years, essentially, trying to leave the South to its own devices. It did not work. In 1879, Hayes understood that it did not work, and he actually tried again. He started prosecuting violations of voting rights again in 1879. So this idea that Reconstruction had come to an end in 1877, the context is a little more tricky. And I think these cases demonstrate that the context is still there, that there are still efforts to enforce black rights in the South. At the same time, they show us that these efforts to enforce black rights in the South were not as strong as they once had been, and that's certainly true. Also, in terms of putting this in context of the end of Reconstruction, we can see that essentially we have black Southerners feeling that there had been some kind of betrayal, right? Black Southerners did feel that the federal government was no longer protecting them as it once had. And so you could argue that the jury movement was an effort for them to find protection by going straight to the judges. You know, William C. Rowan said, we're not doing the president, we're not doing the Congress, we are going straight to the judges this time. So this essentially is an effort to, if you will, find a way to stay safe in the South without the protection that had once been offered by the federal government. So these cases, they enter a lot of context. There's constitutional context with the 14th Amendment. There's the context of the end of Reconstruction, whenever that is. And obviously there's the context of juries too, which, oof, if that makes sense. Cool. All right.
You jump ahead to the 20th century. You recall the remarks of the foreman of the O.J. Simpson jury? You remember those? Could you bring?
I've seen some OJ footage. Yeah.
Well, what she said was to the effect that she was determined that another black defendant would not be railroaded, and she would see to it that would not happen. And that's like the other side of the coin.
It is the exact other side of the coin. That's exactly true. You know, what happened in the OJ case is probably, we would call that as jury nullification, essentially when someone's clearly guilty, but the jury acquits anyway. Usually they acquit in order to undermine a law. Obviously the law that would be undermined is the law of murder. That probably wasn't the purpose that the jury nullified in the OJ case. The jury nullified in the OJ case probably to punish the LAPD, because the LAPD did have a really bad record when it came to race. After all, the cop that found the glove, Mark Furman, I'm sure we all remember this from the OJ case, Mark Furman was recorded saying the N-word and did imply that he had previously planted evidence in order to put innocent black people in jail. So, yeah, by the way, this is not to defend what happened in the OJ case, by the way. I think pretty much all of us agree that OJ did it. And he can't get us for that anymore. May he rest in peace, I guess. Point being,
He shouldn't rest in peace. No.
Well, point being here, yeah, what happened in the OJ case is the other side of the coin, right? That when you have that, essentially that you might have black people who feel zealously in favor of protecting the rights of black defendants to a fault. That was something that people charged black jurors with during Reconstruction, actually. Many white people argued that black people shouldn't sit on juries because they'll probably just acquit blacks and convict whites. That the evidence doesn't really support that idea. Typically, black jurors actually deliberate the same as white jurors do. The OJ case is something of a rather extreme exception. Once again, you know, obviously the OJ case is exceptional in many ways, not just because it's OJ Simpson, one of the most famous people in the world. Once again, we're dealing with the context of LA, the racialized context, the LAPD. OJ was a weird case, no doubt.
Any final comments? Well, let's thank Professor Angelillo. Thank you so much for
Thank you all for
the
being here.
fascinating talk.
I appreciate you. Thank you all for being here.